All right, we're at 2 o'clock now, so I'm going to go ahead and get us started. Welcome everyone, and thank you all so much for joining us for our 24th Annual Elder Abuse Conference, Evolving Interventions and Resources. This year's conference is presented by Caring Transitions of Syracuse. My name is Lauren Ulrich, and I am the Abuse and Later Life Prevention and Outreach Coordinator for Vera House. All webinars offered during this conference are free thanks to the generous support of our sponsors. And this year, in addition to our presenting sponsor, we're fortunate to have 3 platinum sponsors, and those are Onondaga County Department of Adult and Long-Term Care Services, Loretto, and Syracuse Jewish Family Service. I'd also like to acknowledge our gold sponsor, Wegmans, and our silver sponsors, At Home Independent Living, Bousquet Holstein PLLC, Christopher Community Incorporated, Community Bank, Countryside Federal Credit Union, Fulton Savings Bank, Geddes Federal Savings and Loan Association, the Marone Law Firm, and Touching Hearts at Home. And just a reminder, more information about all of our sponsors can be found on the Vera House website at our virtual resource table, and the link to that can be found on our conference registration page. The support of these sponsors not only funds this webinar series, but also extends beyond our conference to continue vital elder abuse education, outreach, and prevention work after this event. Just one final announcement before we begin today. The chat feature in today's webinar has been disabled, but you're welcome to submit questions for our presenter via the Q&A function, and there will be time reserved at the end of today's session for those questions to be addressed. So without further ado, I am very honored to be able to introduce today's session, Fair Housing Rights for Seniors. And it's my pleasure to introduce today's presenter, Sally Santangelo, the Executive Director at CNY Fair Housing. So Sally, with that, I will turn it over to you and invite you to introduce yourself and begin our session today.
Thank you so much, Lauren. I'm really happy to be with everyone today. Let me pull up my screen and share that. So I'm going to talk today about some of the issues that we see at CNY Fair Housing in terms of housing rights for seniors, particularly focused on issues related to discrimination and accessibility, and explain some of what we're seeing in the community right here in Central New York to help people be able to understand what discriminatory practices look like and what the law protects people from. We'll also talk about lease terminations for seniors and some special protections in New York state law to allow seniors out of leases, as well as also to allow individuals with disabilities out of leases if they need. There we go. So a little bit about us, CNY Fair Housing. We're a nonprofit located in Syracuse, but serving 17 counties of central and upstate New York. And we've been around about 30 years. And our goal is we work to eliminate housing discrimination and to promote housing opportunity. We do that in a couple of ways. One is we investigate complaints of discrimination. So if individuals feel that they've been being treated unfairly or facing discriminatory practices in their housing, they can contact us and we investigate those complaints. As part of our investigations and also just as part of our efforts to eliminate discrimination, we do undercover testing, meaning we send people out into the housing market to try to identify hidden forms of discrimination and to provide third-party evidence for fair housing complaints. We also do a lot of counseling and advocacy for individuals whose housing rights are being violated, particularly around the areas of reasonable accommodations and modifications for people with disabilities. We have attorneys on staff also who will provide legal representation to victims if we need to file a legal complaint. And we file complaints in federal and state court, as well as through the administrative process with HUD or the State Division of Human Rights. We also do a lot of outreach and advocacy and education And finally, we conduct research and engage in policy advocacy to increase housing opportunity, including conducting fair housing assessments for different communities throughout New York State. So when we talk about fair housing laws, there are a set of both federal, state, and local laws that protect people from discrimination and unfair treatment. Under federal law, individuals are protected, what we call protected classes. They're protected from discrimination based on race, color, national origin, religion, sex, or meaning gender, disability, and familial status. Federal law is also interpreted to cover sexual orientation and gender identity through how sex prohibitions, discrimination against based on sex is covered and interpreted under federal law. And that's a recent change in the last few months. New York State law also, in addition to those federally protected classes, also protects people based on age, marital status, military status, sexual orientation, gender identity, and source of income. And, when it comes to discrimination against seniors, we do see some age-based discrimination. A lot of times what we're seeing, though, is disability discrimination. So it is the combination of factors where people are facing discriminatory practices. Almost all types of housing is covered under fair housing laws. And the law applies to just about everybody who's involved in the provision of housing. That it can include landlords, their staff, leasing agents and management companies, real estate agents, and as well as lenders, homeowners insurance. And we do see discriminatory practices sometimes by all of these different actors in the housing market. Almost all types of housing are also covered in New York State. In New York State, the only housing that is exempt from fair housing laws are owner-occupied two-family houses. So if the owner lives in one half and rents out the other half, then it's exempt from the fair housing protections. However, race and color protections always apply, even in those two-family houses that are owner-occupied. And then lastly, and importantly for this discussion, under certain circumstances, age-restricted senior housing is also permitted, but it has to actually meet the requirements of senior housing. So it has to be a certain percentage of individuals who are above a certain age, or all individuals, depending on the types of protections. So you can have senior housing that is exempt from familial status protections, but again, it has to be actual senior housing. We sometimes see properties that identify themselves as adult housing, or quiet adult communities, or active adults. And these are problematic terms in terms of the law. There is no such thing as an adult housing. You can have senior housing, but you can't have housing that is just restricted to any adults. It has to have those meet those age requirements. Under the fair housing laws, a number of specific practices are prohibited. So a housing provider cannot, on the basis of one of those protected classes that we identified, they cannot refuse to rent or sell an apartment or a house, or lie about the availability of housing. Most often when we are investigating cases, we're not seeing outright denials where somebody is told that they can't rent or completely denied. A lot of times we're seeing more subtle differences, such as a housing provider lying about whether an apartment's even available or a house is even available for them to be able to rent it. Steering individuals or applicants into certain areas of a building or to different buildings or neighborhoods to segregate populations is also illegal. And this can include steering seniors into particular parts of an apartment complex, for example. And we have seen cases where we've had apartment complexes that have family buildings and that have senior buildings. And this is usually a violation of the law if they're steering individuals to those certain properties or certain parts of the building or certain parts of the property to segregate those populations. Setting less favorable terms and conditions is also a violation of fair housing laws, such as charging higher rents because of somebody, for example, has a disability, or where we've seen individuals charged higher rents where because they have a grandchild who's going to be moving into the apartment with them, which would be familial status discrimination. We see a lot of times differences in the application process or requirements, such as requiring more invasive background checks because of someone's protected status, sometimes because of race or ethnicity or because of disability. Or we see after somebody has moved in, a housing provider may apply the property rules differently, again, because of protected status. Sometimes we see this in relation to children who are being held to a stricter standard in terms of behavior or noise. Or we see this based on race, where lease violations are given for behavior that is maybe allowed by one group and not another. Discriminatory advertising is illegal as well. So any kind of ad that indicates a preference, limitation, or discrimination based on one of those protected characteristics. A lot of times these are, subtle ads that may say things like working people only, or some sort of indication that somebody is not welcome to rent that property. As I mentioned, source of income is a protected class in New York State. And this took effect in 2019, just over 2 years ago now. And what it means is that an individual cannot be denied housing or treated differently because of how they pay their rent, where they get their source of income, such as receiving Section 8 vouchers or public assistance, SSI, SSD, child support, income maintenance payments, any type of lawful source of income. It has to be accepted by a housing provider. Landlords also can't advertise no Section 8 or no PA or no programs. We've been seeing a lot of these source of income cases, and particularly over the last year and a half, as individuals are learning that this is now covered by the law. And we see sometimes outright denials. We actually just filed a case in state court last week that was an outright denial based on source of income. But more often what we're seeing is housing providers creating requirements that effectively eliminate people's ability to rent because of they receive assistance, such as creating an income requirement that an individual has to make 3 times the total rent in order to rent the apartment. And these income requirements or other requirements have the effect of keeping somebody from being able to rent the apartment and are therefore likely a violation of the law. We also just filed a case on that issue last week as well, where a housing provider had an income requirement that effectively eliminated a voucher holder from being able to rent. So we can investigate either types of, whether it's a direct denial or it's a policy or practice that has the effect of keeping somebody from being able to rent an apartment. So in terms of fair housing laws and senior populations in particular, we most often see these issues come up with relation to disability. So federal, state, and local law all prohibit discrimination based on disability. And disability actually accounts for more than half of our fair housing cases, both locally and nationally. New York State also prohibits discrimination based on age as well. So anyone over the age of 18 who can enter into a contract is protected from age discrimination. And I'll talk a little bit about how we see age discrimination play out sometimes in some of our cases. In addition, under those disability protections, housing providers have to meet accessibility standards, and they have to provide for reasonable accommodations and modifications in their housing. And I'll explain what that means and what that looks like in more detail. So one of the first issues we see a lot is related to those accessibility standards, what we call design and construction. So any building that contains 4 or more apartments, so basically any apartment building with 4 or more apartments that was built after 1991 has to meet certain minimum accessibility standards. It also applies if a building is substantially rehabbed. So if a building is renovated, more than 50% of the structure is renovated, the law also applies to those properties. Now, in the city of Syracuse itself, most of the buildings we have here were built before 1991. We do have, but when you look in some of the more suburban communities, we do have some newer housing as well in the city. Those types of properties would have to meet these accessibility standards. There are 7 basic requirements that have to be met, and I won't go into too much detail of these, but I will show some examples of what common violations that we see that you may see in your own housing as well. So those 7 basic requirements is that the entrance to the building has to be accessible and on an accessible route, meaning there has to be an accessible path through or into the building. You have to have accessible common areas and any public use areas, like a rental office would have to be accessible. Or if there's storage units that are provided and also available for public use, those would have to be accessible. The property has to have usable doors, meaning a door wide enough to be used by a person in a wheelchair. You have to have an accessible route into and through the apartment, meaning also through to any patios or balconies that may also be part of the unit. And I'll show in a moment how that's a common source of violations that we see. Any kind of light switches or any kind of environmental controls and outlets have to be in an accessible location. Reinforced, the bathrooms have to have walls that are reinforced in case there needs to be grab bars installed at a later date. And the property has to have usable kitchens and bathrooms, meaning that there has to be enough space to be able to maneuver a wheelchair in either the kitchen or the bathroom. And there's some specific whole, guidebooks on exactly what's required of these properties. And if you ever have any question, we can certainly look into it and investigate further. But I'll show you some examples of some of the common issues that we see, because these may come up in your properties. Now, again, this is any properties built after 1991. So common violations we see include thresholds at the doorways, especially thresholds at balconies and patios, not being having a too high of a lip or perhaps a physical track. We see it a lot with sliding glass doors where you wouldn't be able to maneuver a wheelchair over that threshold. We see doorways that aren't wide enough. There's an example here showing a sliding glass door that is not wide enough for a wheelchair to be able to use. As I mentioned, not enough space in bathrooms or kitchens. Common areas like garages or storage spaces or mailboxes not meeting accessibility standards. Sometimes we see those again with those large thresholds, or we see mailboxes that are too high for an individual to use. Rental offices often not accessible either. And we see sidewalks that maybe have insufficient curb cuts or an excessive slope, and meaning that it's very difficult for a wheelchair user to be able to maneuver because of the slope of the sidewalk. Or we see, there's a picture here showing a sidewalk that goes into a grass strip and then into the side of a car, into the side of a parking space if there was a car parked there, which is not a sufficient and appropriate curb cut. Before I move on, if you have any of these issues, you can always contact us. I'll have our contact information at the end, and we can always investigate. Our staff is trained to look at these properties, and usually we can work to try to get the issues resolved with the housing provider. And a lot of times what we have found with these properties is that housing providers actually think that they've met the right standards. They actually think that they followed the rules. But what happens is decisions are made on the construction site that often end up changing those accessibility standards. So we saw, for example, in one property where they decided to make the concrete outside of a doorway smaller. And because they made that concrete smaller, they couldn't make the door go out, and they had to instead make the door go in. And by making that door go in, there wasn't enough room for a wheelchair to get around the stairway inside. And so the property didn't even know that they had this violation. It wasn't until a wheelchair user moved into the building and wasn't actually able to get in and outside of his apartment on his own independently. And then they realized, oh, we built this wrong. We didn't follow the architectural standards and the accessibility standards that we should have followed. And we were able to investigate and have them fix that. And they actually fixed the door, I believe, and moved it so that it opened the right way. Okay. Next, I'm going to talk about reasonable accommodations and reasonable modifications. So a reasonable accommodation is a change or exception or adjustment in the policies, practices, or services offered by a housing provider that allow an individual with disabilities the full use and enjoyment of their dwelling and any related facilities. So, for example, allowing assistance animals in housing that is normally no pet housing, allowing assigned parking spaces as an exception to a first come, first serve parking rule, maybe transferring units because of a disability related need, or changes in communication methods, such as offering documents in Braille or offering interpretation services. Trash pickup. We've had cases where we've arranged where individuals have mobility impairments and are unable to access their dumpster, for example. And so we've arranged to have the housing provider change the methods by which they pick up trash. Changes in snow removal practices, where you have maybe somebody who struggles to remove snow on their porch, and they instead ask their landlord to remove the snow on that porch. And another example we see is leniency for behavior that violates a lease. If you have somebody who has behavior that is related to a disability, that maybe is a lease violation, such as disruptive behavior, or there may be instances in which you can ask for an accommodation for some leniency for that behavior. The question with all these cases is whether it's considered reasonable, which I'll talk about the legal standard for what's considered reasonable. This last one comes up sometimes also with hoarding, where you have individuals with a hoarding disorder who maybe have been given lease violations because of that. And we may seek a reasonable accommodation to try to, usually just to try to get them some more time and then try to get them some services to help them address the issue to keep them in their housing. Now, reasonable modifications are similar, but they are physical changes that are made to allow individuals with disabilities, again, the full use and enjoyment of their dwelling and related facilities. Common modifications that we see can include ramps, grab bars, sidewalks, power-assisted doors. We've been doing a lot of power-assisted door cases lately where individuals, properties that are not covered under those accessibility standards, they don't have to meet those accessibility standards, but you have individuals who live in those properties who still have those needs. And we're asking the housing provider to provide those power-assisted doors. Flashing smoke alarms or flashing doorbells, another common one that we see. Under fair housing laws, disability is any person who has a physical or mental impairment that substantially limits a major life activity. And common examples here, we see mobility impairments, visual or hearing impairments, major diseases, mental illness, depression, anxiety, post-traumatic stress, and autism are the most common that we see in terms of the types of cases that we investigate and advocate for, and sometimes, as I said earlier, file legal cases. With all of these accommodations and modifications, the question comes down to what is considered reasonable. And it is always on a case-by-case basis, but there is some case law and some standards set forward by the Department of Justice and by HUD that kind of lays out what's been considered reasonable in the past and what the standard for evaluating those cases is. So what is considered reasonable are any changes that do not impose an undue financial and administrative burden or would fundamentally alter a housing provider's operations. And in sometimes in the case of looking at a change for an accommodation from a local government, it would apply to their zoning scheme. That doesn't come up that often, but we sometimes see that on disability-related issues. Those, what's considered undue financial and administrative burden takes into account several factors, like what are the resources of the housing provider? What are the costs of the accommodation? And what benefit would it provide? And are there other alternative options? Insufficient reasons for denying an accommodation or modification include aesthetics, such as a ramp wouldn't look good at the property. That is not a sufficient reason to deny somebody a modification. Or claims that everyone will want the same thing. We hear this a lot with assistance animals in particular, or assigned parking spaces in particular at senior housing. Or that it's not fair to other individuals. With any accommodation or modification, it's really about the needs of the person who's asking for it, not how others will feel about it. What is considered fair is that everybody gets what they need, not that everyone gets the same thing. And then lastly, that there's a reasonable cost involved. There are instances where an accommodation may cost a housing provider money, and a modification may cost the housing provider money, and that is an insufficient reason to deny. With those modifications, those structural changes in federally subsidized housing, which includes public housing or other HUD subsidized housing, the housing provider is responsible for paying for the costs of all modifications. In private housing, so most apartment complexes or buildings, the tenant is responsible for paying for modifications within their unit, while the landlord has to pay for modifications, for some modifications to common areas. The distinction is whether it's going to be something that benefits others individuals or just that one individual requesting the modification in terms of whether the landlord has to pay for it. So for example, if you had an apartment building with 10 units and you had a tenant who needed a ramp, that ramp would benefit and be used by other tenants. And so the landlord would have to pay for that ramp. If you had a single family house that a tenant was renting from a landlord and they requested a ramp, the tenant would be responsible for paying for that because it wouldn't be a common area that would benefit in a commonly used feature. Now, if the modifications are necessary because the housing provider failed to comply with those design and construction standards, then the housing provider is responsible for paying for the modification. So for example, if a housing provider, when an apartment building is built and they put in a sliding glass door that it has a threshold that is too high for a wheelchair, and an individual wants to put a ramp on that door or have the door replaced, the housing provider would be responsible for paying for that modification if assuming that door violated those design standards. When somebody is requesting a reasonable accommodation or modification, the request doesn't need to be made in any particular way. The tenant just has to make their needs known to the housing provider. We do recommend that requests be made in writing and also ask that the housing provider respond in writing as a best practice. A housing provider may also have a particular form or process that they use for requesting accommodations or modifications, but they can't require that tenants use that form or process. they can ask a tenant to use it, but there's sometimes a reason a tenant may not be able to use that form or process. Maybe they can't get to their doctor, or they can't, you know, or they've already requested and it would be a burden on them to use that particular form. If a person's disability is not obvious, they should be prepared to provide information from a third party that meets these standards. First, it has to verify that they meet the Fair Housing Act's definition of a disability. It has to describe what the needed accommodation or modification is, and it has to show the relationship between their disability and the need for the requested accommodation and modification. It doesn't have to contain and shouldn't contain a specific diagnosis, though oftentimes it's hard for that third party to provide the explanation without revealing some of the symptoms of the person's disability. And if a person, in terms of what's obvious, if a person is a wheelchair user or has an obvious, uses a mobility aid, that would be considered obvious disability, and the housing provider should not ask for verification for that. Also, that documentation, just going back real quick, that documentation does not need to come from a doctor or therapist, but it should come from somebody. Ideally, best practice is that it comes from someone with some professional expertise related to the individual's disability, whether that's a licensed social worker who does treatment for a mental health disability, or a doctor or physical therapist who treats somebody for a mobility impairment, for example. Housing providers cannot charge fees as a condition for granting an accommodation. And that includes pet fees and pet deposits for somebody with an assistance animal, whether that's an emotional support animal or a service animal. Parking fees, for an assigned parking space, or transfer fees if an individual needs to switch units for a disability related need. It also can't be changed, the name can't be changed to something like an administrative fee. And we have a case right now pending in federal court where the housing providers allegedly was charging a parking fee. And when they were asked by our staff here and informed that they shouldn't charge the fee, changed it to an administrative fee. Sorry, real quick, before I switch to that next slide, a housing provider also should not place excessive restrictions as a condition for granting an accommodation or modification. So in the case of an assistance animal, a housing provider should not, for example, we've seen instances where a housing provider is asking that an animal be removed from the property to use the bathroom, to go to the bathroom, or they're being told that the animal can't be in any common areas, or they try to place breed and size restrictions on the animal. Again, those would be considered excessive restrictions. Reasonable restrictions would be things such as having the animal leashed when it's in common areas, or picking up after the animal, or having the animal making sure the animal has required rabies shots or vaccines that would be required by the community. Or if the town requires registration of the animal, for example, then that, like a registration for a dog, that would be a reasonable restriction on the animal. In addition, when requesting the verification from a medical provider, there may be instances where an individual is unable to provide that verification from a medical provider. We've had cases where individuals were maybe struggling to access mental health care, for example, or they were unable to get to their doctor. That's been a particularly obviously difficult thing for people over the last year because of the pandemic. And so there may be instances where an individual could self-certify that they have a disability and that they need the accommodation or modification. And again, those are limited circumstances. With assistance animals, there are websites that do purport to provide these certifications for those animals, and they charge a pretty hefty fee to provide those certifications, but we don't recommend using those websites because we find they're actually somewhat predatory. And also those certifications for those emotional support animals aren't actually authentic. An emotional support animal does not need to be certified in any way and does not need to be trained because the service it provides is emotional support and not something that it would need to be trained for. And then the last thing I'm going to talk about, and I'm happy to take questions shortly, is senior citizen lease terminations. So under New York state law, any tenants or their spouses living with them who are 62 or older, or who will turn 62 during the term of their lease, can terminate their leases early under certain conditions. So they can terminate their lease early if they are certified by a physician as not being able, as being no longer able for medical reasons to live independently. And they're moving to either live with a family member or relocating to an adult care facility or subsidized low-income housing or other senior citizen housing. This is particularly important given that we often have long waits for subsidized low-income housing, and you really don't know when you might be able to move in to those properties, and you're not sure when that's going to become available. So it allows you to vacate a lease in the middle of the term, so you can feel comfortable recertifying your lease and renewing your lease if you are on a waiting list for one of those types of properties. Now that notice, though, that you still have to give notice, but the notice has to include a termination date, which is no more. Must provide a termination date more than 30 days notice from the date the next rent payment is due. So today is June 22nd. If you normally pay your rent on the 1st of the month, you would pay your next rent on July 1st. The notice would have to be 30 days from that July 1st, so August 1st. Generally, it's a calendar month from the next date your rent is due. The physician's you need a physician certification that the individual can no longer live independently for medical reasons. And if you're moving in with a family member, you need a notarized statement from that family member stating that the senior is related to them and will be moving into their residence for at least 6 months. Or if you're moving into one of those covered facilities, you would need documentation of admission of a covered facility. And then lastly, I'm going to talk about harassment under fair housing laws, because harassment is protected or is a prohibited practice. And it is something that we do see in relation to particularly sometimes at senior properties. So harassment, individuals are protected by fair housing laws from harassment based on age, gender, and any of those other protected characteristics, disability. We see different types of harassment at properties. Sometimes we see sexual harassment, which can include things like lewd comments or gestures made to tenants. Sexual harassment under fair housing laws does not just include quid pro quo harassment or any kind of harassment that involves exchange of sexual favors, but it can include making someone feel uncomfortable or making somebody feel creating a hostile environment based on somebody's protected status. So creating a hostile environment related to their age or to their gender. We sometimes see properties or instances where the housing providers or staff making derogatory comments about an individual's disability or their age. Or instances of individuals being given excessive or unjustified lease violations. Sometimes we see these as retaliatory practices. So if an individual has, for example, requested a reasonable accommodation, we sometimes see them get lease violations afterwards for things that don't seem to be justified. I remember one case we had a tenant who had requested a reasonable accommodation and after got a lease violation for having a bird feeder too close to their apartment window. Obviously not needing a lease violation, they could have just asked the tenant to move the bird feeder away. And then we also see properties where you may have the property manager or staff who are overly paternalistic and overly involved in the activities or lives of the tenants. And this could be amount to harassment. And depending again on the nature of that behavior and how intrusive the housing provider's actions or comments are in terms of interfering in the lives of the tenants. If you are a victim of harassment or know someone who's a victim of harassment, you can contact the police if you feel threatened or if the individual is threatened. It's a good idea to document what's happening, or you could record any interactions that you have with the harasser. In New York State is what's called a one-party consent state, meaning you can record a conversation without the consent of the other individual. So if you are, for example, every time you go to do your laundry or you go to get your mail, there's an individual who's making derogatory comments or inappropriate comments, you can put your phone on record and record that conversation if you know that that's something that happens regularly. Keeping a journal, writing down what's happening, what interactions, with dates and times and specifics of what is happening can be really helpful in terms of if there were a case, if we had to pursue a fair housing case for harassment. And you can notify your housing provider. Again, it's a good idea to put that in writing or ask for a complaint report or some kind of verification to that housing provider that you have notified them of what's happening. But you have the right to be safe in your home. You have the right to be comfortable in your home, and as well as the rest of the property. So I'll see one question. I'll get to the Q&A in a moment. I did want to talk briefly about parking. Because I mentioned it briefly, that with assigned parking spaces at senior housing, I know can be a difficult issue as individuals, when you may have a lot of different individuals who have different disability related needs. Generally, best practice, I think, for a housing provider is to provide assigned parking spaces on a first come, first serve. So as an individual requests those specific spaces. But an individual, if they need a specific spot close to their apartment or may want a specific spot for a different disability related need, that is generally a recognized reasonable accommodation that should be provided. And it's difficult to balance the needs of, sometimes it can be difficult to balance the needs of one individual versus another, which is why it's better to often do the first come, first serve in terms of those choices, those spots. A lot of times the things tend to work themselves out in terms of where individuals live and what's the best thing for them. So question in the Q&A, can a senior terminate a lease for issues of abuse? As an example, if they have concerns because an abusive person has access to their building and wants to move to a new anonymous location for safety reasons. So yes, an individual could terminate a lease if they are a victim of, if they have experienced abuse and they feel threatened or continue to feel threatened, they can request a termination of their lease. In addition, if an individual experienced, this actually came up, I think yesterday I had somebody who had this question or issue where an individual was actually sexually assaulted in their apartment and wanted to terminate their lease because of the trauma that they experienced, and they didn't want to be in their apartment any longer. I think in that circumstances, they also could terminate their lease as a reasonable accommodation because of post-traumatic stress in that situation. The senior citizen, there's several different laws at play here. So let me make sure I explain each of them. So a senior can terminate their lease under New York State Tenants' Rights Law. Separately, you can ask for a lease termination as a reasonable accommodation. And then third, there is a lease termination provision under domestic violence laws and domestic violence protections in New York State. So in this question about the lease, terminating a lease for issues of abuse, those domestic violence protections would be the best option, would likely be the best option, because it is about whether that person has access to their building and they no longer feel safe. In the instance of when someone has trauma or experienced trauma, there may not be that continued threat in terms of actual physical threat. So they may need to ask for that as a reasonable accommodation. Okay, next question. Can older adults get priority on a waiting list if they are victims of domestic and sexual violence and elder abuse? So it's possible that they could get an individual could get a preference on a waiting list, but it would depend on the particular property or the particular program. So, for example, some housing authorities have a priority for individuals who are domestic violence survivors. So there may be an instance where somebody has a priority because of that, or certain properties may have that as a priority. Most often I've seen it is housing providers having that as a priority or a preference in those cases. I'm trying to think if other properties, it can be, I'm trying to think if short of a housing authority, if other properties would have that. I think they would have to have a preference, established preferences, which you usually only see with a subsidized type of housing program. But it's possible you'd have to ask that individual property or the individual program that's administering that if they have a preference for that. Okay, next, can landlords have security cameras set up anywhere they want? A landlord could have security cameras in common areas, such as the backyard, as long as it wasn't recording within their the apartment. I'm trying to think with a specific circumstance where that maybe wouldn't be okay. So like if it was an apartment complex, you could have those in common areas. But not as, you would want to make sure it's not pointing into someone's apartment specifically. I hope that answers that okay. Yes, you can get a copy of that presentation. That was an easy question. Next questions. Are landlords able to enforce orders of protection for their tenants? would that be an accommodation? So a landlord could have a no trespass order against an individual if, for example, somebody had a an order of protection. The landlord could also have a no trespass order against that individual, and yes, they could enforce that. The landlord could tell the individual that they're not allowed at the property and can call the police themselves if the individual is on the property. We've even recommended to landlords that if you have a tenant who does not have an order of protection, but they have but you have a no trespass order against the abuser, that the landlord does enforce that themselves and not put that on the tenant to enforce that. So yes, a landlord can enforce that, but they should probably get a no trespass order against that individual. And then again, call the police if they see the individual at the property. What if harassment is from another tenant? Working with a 97-year-old female being harassed by a 45-year-old male. Police have been called several times. The landlord says she has no rights to evict them. What do you advise? So unfortunately, there's some really bad recent case law in New York State related to tenant-on-tenant harassment. So the answer I would have given 6 months ago is different, unfortunately, than the answer that I have now. If the individual is breaking the law, so if the harassment amounts to the individual breaking the law or any other type of lease violation where they're disrupting the quiet enjoyment of other neighbors, then the landlord probably does have the ability to act to evict that individual. I think a lot of times landlords don't want to take hard actions against individuals. And especially when you have a case where it's not clear, right? It's not, if the landlord hasn't witnessed it themselves, for example. So the landlord should be able to, assuming there is a lease that says that that tenants have the right to peaceful enjoyment, and that the person who is the harasser is violating that lease, then it would be, they should be able to act. What the recent case law is that there is no fair housing requirement for a landlord to intervene in tenant-on-tenant harassment, but that doesn't mean that there is no requirement for the landlord to intervene if, again, it's disrupting the peaceful enjoyment or if it is a criminal act. If they're committing a crime on the property, the landlord can move to evict that individual, whether that crime is because of again, a protected class or type of harassment. So the landlord does probably have the right to evict them. One of the things you can do in this specific instance is look at the lease. It's more likely than not that it's the same lease for the 97-year-old as it is for the 45-year-old. So you can probably just look at the lease. It's probably the same one, and see if there's something in there that prohibits that behavior, and then you can look to move to help encourage the landlord to take action in that circumstance. Unfortunately, tenants don't have just generally a lot of the much ability to proactively enforce their rights against landlords. One of the only ways a tenant can really enforce their own rights against a landlord can be by withholding rent. So if that may be one of the only options. If you need, you feel free to reach out to us on this one, and we can help see if there's anything we can do to help encourage that landlord to protect the rights of their tenants. And I think that is all the questions I see. in the chat. All right, Lauren, I'm going to go ahead and stop sharing so we can finish up.
All right. Well, thank you so much for this incredibly informative presentation, for sparking such important discussion as well. I feel like I definitely learned a lot, and I feel like we all did learn so much that we can use to help ourselves and potentially older adults that we could be working with. So thank you so much for taking the time to share your expertise with us today. We greatly appreciate it. Thank you.
Thank you for the opportunity. Again, we're always available to assist if you have questions we can always investigate. Also, even if the individual doesn't want to pursue a case, if you have, if a caseworker wants to call us and tell us about some issue that they're seeing, we may be able to investigate it even without that individual. So to help protect everyone else in the community, anyone else that lives at that property. So please let us know about any issues that you see.
Excellent. Thank you so much, Sally, and to everyone who is on with us today. Thank you so much for coming. We really appreciate it, and I hope you have a wonderful rest of the day. Take care, everyone.